Good. All right. Well, welcome everybody. Thank you for joining our Lunch and Learn. And Nathan, thank you for joining, even though you're wearing a team that will have a little bit of heartburn with, even though you're wearing that jacket, welcome. No, we appreciate your willingness to join us. I know we've talked about trying to get you here in person, but one of these days. Yeah. So yeah, welcome everybody. Today's Lunch and Learn, which is IT contract red flags with Nathan Dawson. And I'm going to let you do the introduction with that, Megan. So I'll just run through the chapter slides. So thank you. So we do have some upcoming events I want to let everybody know about. We still have some people who are logging in, but on coming up for our classes, we actually have 2 classes coming up, May 19th and June 14th. You can see those on the slide, so make sure you get registered for those. Those are virtual classes, so anyone can join those. And then our next Lunch and Learn is coming up on June 7th, which is going to be with Cheryl Mankey, and she'll be doing environmentally preferred purchasing. And then one of the ones that we've just put on the calendar and didn't quite get into the upcoming events is next Wednesday at 2 o'clock will be our first emerging professionals group. So we had our kickoff earlier, and so we will be doing our emerging professionals. So please make sure you have to register for that. So go ahead and get online and go to our calendar and register for that. All right, so a couple housekeeping items. If we could go ahead and mute ourselves, so that way everyone can enjoy the, Nathan, you can't mute yourself, but the rest of us need to mute ourselves. So, and then for those of you who are looking for credit, we do need your full name. It's really, really hard if we're trying to guess what your name is. You just won't get the credit for participation. And then, Nathan, are you going to want questions while you're doing your session, or would you prefer for us to wait and get those all answered at the end?
Either way is fine with me, Maya. I actually probably prefer them during, just because I have the slide up. Right. And Jermaine. So it saves people from having to go, remember about 12 slides before you said this. So I have no problem with interrupting.
Okay.
I save some time at the end. So if people want to wait till the end, they can. But if it's burning them up, then go ahead.
Sounds good. So then we'll ask you guys to go ahead and raise your hand. And then I think either Victor or Kara will call on you and kind of let Nathan know that there's a question, because I know, Nathan, it's really hard to juggle all of that. So we'll try to help you out with that, or go ahead and drop it in chat. And again, we'll just let you know that there's a question in chat. So, and for those of you who are still new to Zoom, remember you can go down to the reactions and then there's a raise hand there. So with that, I'm going to turn it over to you, Megan.
Perfect. So everybody, please, let's give a really big warm welcome to Nathan Dawson. He is no longer the Director of Procurement at Lexington Country School District. Yesterday was his first day at a new job with the state of South Carolina. But I'm not going to cruise through his intro because I know he's got a ton of things to talk to us about. I'll keep an eye on the chat if anybody has anything, along with Victor and Kara. But Nathan, I'll turn it over to you.
Thank you, Megan Waltari. Welcome, everybody. Thank you for having me. For those of you who don't know me, my name is Nathan Dawson. As you can tell from the accent, I am not in Washington State. I am in South Carolina. I've been here for 17 years, originally from Australia. As Megan said, I'm in day 2 of a brand new job with South Carolina's Office of Technology and Information Services. Before that, I was the Director of Procurement at Lexington County School District 1. And before that, I worked for the Division of Procurement Services, which is our centralized agency here in South Carolina. So I've been doing procurement for a while, mainly involved in IT. My new job, I'm really excited because that's all I'll be doing, which terrifies some people, but I actually kind of geek out on it a little bit. So it's good for me. And I also teach and instruct for WANIGP. A lot of different classes, but the main 2 ones I do are the technology procurement classes. So a lot of this stuff comes from there. So based on all of those things and the fact I'm a recovering attorney, I think that sort of qualifies me to speak to some of this. So I'm going to share my screen because I forgot that I unshared it. As I said, if anyone has any questions, please feel free to raise your hand or shout out or whatever you want to do. And Maya, before I get going, I am a Red Sox fan, but I'll let you know the first MLB game I saw was the Mariners at the Kingdome.
And you weren't hooked from day one with our
Oh,
fantastic track record?
Ken Griffey Jr. hit one out that day too. It was glorious.
Yeah.
And they've stunk ever since.
They have.
Unlike the Red Sox,
They have had their moments.
unlike the Red Sox, who are amazing every year. So moving along. IT contract red flags. Here's some objectives. These to help keep me on track and just so you have some sort of idea of what we're going to do. Hopefully it's a super quick session and we've got a lot to cover, but I think we'll be okay. The idea is that at the end of the session, you'll be able to identify some of the risks that are contained in IT contracts and agreements or MOUs or whichever acronym you want to use. You'll understand sort of how to assess the level of risk that you're facing once you've identified one. And then we're going to talk about how to mitigate those risks by amending the language in the IT documents themselves. So that's the plan. Let's see how it goes. Question one is, why is it important? I think everyone's realized now that everything has an IT component. I was in Home Depot recently.
Good afternoon.
Good afternoon. And I was buying a fridge. And I don't know if anybody's looked at the fridges lately, but even fridges now have an IT component. There was a fridge with a touch screen and I could watch the news. I could pull up YouTube videos. It would even access how many eggs I had left in my fridge. And if I took the last egg, the fridge will automatically contact your bank to see if you have enough money to buy some more eggs. And then it will contact Jeff Bezos and he will airdrop those eggs at your house. So everything has an IT component. Even if you're buying locks now, I bought some locks recently for the school district. It's not just a question of buying padlocks and someone coming out and changing them with a screwdriver. It all had an IT component. I had to buy maintenance and support and software and integration and all those sorts of things. So as a result, the percentage of your entity's budget that's being spent on IT related goods and services is constantly and rapidly increasing. And as you know, the more money you spend, the more risk there is, right? The more exposure there is for your entity. And as procurement professionals, those entities, rightly or wrongly, are looking to us to reduce that risk and to keep them safe and to keep their data safe. And that's why this is an important topic. And I think it's one that we're all facing more and more each day. And IT especially is one of those things where sometimes you just don't know what you don't know. Right? So it's all terrifying because you have just no idea where to begin. We've gone backwards, let's go forwards. For those of you who are like me and you like pictures better than words, there is an idea. The spend on IT and business technology in the United States from 2012 to 2022, you can see the increase there and it's not coming back down. So step one, identifying risk. What are we talking about when I say risk? Risk is anything that could harm your entity. And it's pretty self-explanatory. But the trick is to remember that it can directly harm you, or it can directly harm your clients or your customers or your stakeholders. So it's not just the entity, but it's the people that you serve and the customers that you have. The other thing to bear in mind is that the damage that's done is usually measured in monetary terms, like dollars. How much is it going to cost to replace the system or buy a new system, or how much is it going to cost us because our system is down? But it's also important to remember that harm can be done to your entity's reputation and your goodwill. And so, for example, in the case of a data breach, you know, if all of your clients' information is now public knowledge, that hurts your good reputation. And for those of you who have been in that situation before, you're painfully aware how hard it is to build that reputation back up. So that's what we mean by risk. Let's start with identifying the risk. Here are some examples of risks that you might find in an IT document. And when I say IT document, I'm talking about contracts. You might see a SaaS agreement or software as a service agreement. You might see an SLA or a service level agreement. You might see an MOU or a memorandum of understanding. You might see a privacy policy, terms and conditions, terms of use, terms of service, all of those documents that the vendors like to bombard you with, usually double-sided in 2-point font with no breaks in paragraphs, and everything's justified. So here are some that you may have seen. You may have seen all of them, or maybe you haven't seen any of them. They're the top 15 that come from one of the IT NIGP classes. Obviously, that's way too many, although if anybody has any questions on any of those specifically, I'll answer them. But on the next page, I've sort of grabbed the top 7. So here are the ones that I've seen the most often, looking at the documents that I look at. Not spending too much time on each of them, but I'll just go touch on them briefly. Indemnification is a fancy lawyer way of saying compensating for loss. So what the indemnification clause says is if the contractor suffers damage as a result of performing the services under your contract, your entity may be required to make them whole again and repair them from that damage. So obviously that's a risk. I think governing law is a fairly obvious one. Most software companies try and make sure it's the law in their state that governs. Automatic renewals is another one. They will always try and set it up so it automatically renews. And sometimes it doesn't just automatically renew for 1 year at a time. I've seen it where the first year is 1 year, and then it's an automatic renewal of 5 years thereafter. Termination rights. What's important to remember there, and I'm sorry, I was just looking at the chat really briefly. What's important there for termination rights is not only are you talking about how you can get out of a contract or how you can end it, but perhaps even more importantly, how do you get your data back when that thing terminates? And in what form do you get it? So those are the sort of risks involved with termination rights. Liability, supplier liability is a common one. You've probably heard of it as LOL, or limitation of liability, although ironically it's completely not funny, so it's not LOL. Suppliers are always going to try and limit their liability in the event that something goes wrong. And if they are limiting their liability, guess who is picking up the shortfall, and that's you. Sole document is another common one. That's where the vendor tries to say that the document that you're signing is the only document that will be referred to and relied upon, and anything that went before it is negated and does not apply. Amendments don't apply. Solicitation doesn't apply. The original proposal doesn't apply. Obviously, as procurement people, we want that one gone, right? We sweat blood and tears over the drafting of those specifications in that solicitation, so we want those to be part of the suite of contract documents. If you're not careful, that sole document clause, if you've signed that agreement, all that hard work you've put into the solicitation is now gone. The last one, and I'll come back to the chat questions after I touch on this last one briefly. Terms and conditions links is a super common one. What I mean by that is you'll often have a hyperlink in the document to another document. It might be to a privacy policy, or it might be to another terms of use or terms of service. And they say that by signing this paper agreement, you're agreeing to this document that's contained at the hyperlink. Well, the problem there is that those hyperlink documents are what they call living documents. So what that means is the hyperlink will stay the same, but the terms and conditions in that document can change. So you might sign that agreement, and then 6 months later, they go ahead and they change the terms and conditions in that hyperlink, and then you're bound to those new terms and conditions because of what you signed in the original document. So looking at the chat, Megan has said to work with your legal counsel on indemnifications. That is very true, and we'll touch on that briefly. Making a vendor whole may be seen as a gifting of public funds. That's an interesting one. I hadn't thought of that before, but you're right. And click-through terms. Aaron Hamilton asked. So the click-through terms are the ones, we've all seen them and we've all done it. I've done it. When you get an app on your phone and it says you agree to the terms and conditions, and you really, all you're trying to do is open that and click that, so you can open the program and get it working. Aaron, the short answer is you try and negotiate so that there's no click through or shrink wrap or anything involved in the software when it's installed. The other thing that's important to try and do is to incorporate in your IT training. So, you know, whether you have phishing training and all those other things that the IT department makes you do to make sure that you're not opening emails from Nigerian princes and things like that. Something that's important there to do is include that in the training. Make sure your staff know that they're not to click on any terms and agreements. Even if it's approved software from your IT department, they need to contact somebody to discuss that because it should not be in there. I hope that answered your question. Any questions on any of the others? That was a good question, Aaron. Thank you. Okay. So now that I've terrified you and made you realize that there's a whole bunch of risks in these things that you didn't even know existed, how can we spot them? Well, I'm afraid to say that there's no substitute for doing the reps. The first thing is practice. Practice, practice, practice. How do you get to Carnegie Hall, Victor? You practice. So the trick is, the more of these things you're exposed to, the more that you read, the more you'll learn what to look for. And funnily enough, you might even see the same sorts of, I won't say tricks, but the same sort of methods are used by the vendors to do things. And so there's no really, that's the best way to do it. Having said that, you're not in a vacuum, right? We have other resources available to us. So within your entity, you may have an IT department. Most do. You may be lucky enough to have a risk officer or business assessment, risk assessment, chief information security officer, whatever they're called. And you may even have legal counsel, in-house or external legal counsel. Use them. Use those resources. I think that you're the first port of call as procurement, but use all of those people because there's jargon involved in these things deliberately to try to confuse you and obfuscate things. So lean on those folks there. If you're in a small entity that doesn't have access to some of those things, use your external resources. This Lunch and Learn is it's a great idea. And I've met a lot of you from the Washington chapter, and I've enjoyed meeting every single person there. And I think you have a really good chapter. And the ones that I've met and Victor are happy to help. And I think if you reached out to anybody that's in your group, they'll help you if they can. Outside of that, you have any of you that use the WANIGP Insight communities. I found them very helpful for people when I'm asking questions, or have you seen this before? How do I deal with that? There are professional bodies that can help you and just other networking. So you're not alone. The key though, is to read the documents. As I said, the more you get, the better, but you got to read them carefully. And by that, make sure that the acronyms they're using stand for what you think they stand for, right? Make sure that you read the definitions. That's usually the first thing that everybody glosses over, but that's where they could define a term in a specific way that you're not used to, either in other contracts or just in everyday language. So read them as carefully as you can, make sure you understand them, and that should help you spot those. So now we've spotted them and we've seen that there's a potential risk. The next step is to assess them. Not all risk is created equal. So how do we assess that risk? Here are some basic questions that you need to ask. What you need to look at is how critical is the solution that you're procuring? Is it an important aspect of your entity's operations, right? How many areas or departments does it impact? And if you can't use that solution, are there any other alternatives available? So all of those questions, all those answers to those questions is going to help you determine how big a risk is this, right? If it's an entity, an ERP, an enterprise resource planning system that every facet of your organization is going to touch, then it's a big risk because everybody's going to be using it and it plays a crucial role in what it is that you do. So you are probably going to have to assess that risk, and address that risk. If it's something that perhaps is not as critical a component and there are other alternatives available to you, maybe it's not worth addressing or assessing the risk at all. You just leave that vendor and move on to number two, right? So that's the first question. How critical is what I'm buying to what we do? Second question, how expensive is it? How big is the spend? What portion of your budget are you about to drop on this thing? And then what are the financial implications if you do not procure it? So again, the more it's going to cost you, the closer you need to look at these things and the more you need to address them. If you don't purchase it and it's not a big impact and you can move on with your business day to day, then suddenly it's not as imperative that you would assess and address every single risk that you identify in that document. You can live with a bigger risk, right? The third question is, what are the repercussions? If we buy this solution and it fails, either temporarily or permanently, what will happen to us? If there is a data breach, how will that affect our entity? So if we don't address this risk and we let it slide, can we live with the exposure if something bad happens, right? Can we live with a data breach? So for example, if you're buying a software solution and the only data that is going to be in there is data that would be publicly available anyway under a Freedom of Information Act request, then maybe you're fine with that risk. It's not that crucial or important. But if it's working at the school district, if it was student data and information, I can tell you firsthand that the parents take that stuff very seriously. Your entity might have employee financial information. It might have health information. So suddenly the repercussion from that being exposed is much bigger. There's a lot more at stake. So you really have to take bigger steps to address the risk that you've identified in that document. The last question is, how risk averse are you as an entity? How does your leadership team feel about negative publicity? I talked earlier about reputation and goodwill. So how important is that to you and your management team? It's something I like to call the front page test. For those of you who are old like me and Victor, you probably remember newspapers, and the really important stories were put on the front page above the fold because they were the ones that everybody saw. That's the last one, Victor, I promise. So if your entity, if you woke up the next morning and the first thing that you clicked on, or the first thing in your feed, in your social media, was your entity's name, how would your leadership team feel about that? And that's something you got to look at, because it's one of those things where the data might not be that bad, and financially it might not be that big of a hit to you, and nothing really truly bad has happened, but you might be the only people in the world that know it. And the way it's spun in the press and the public at large may make it seem like it is the absolute worst thing that could ever happen. And so it's the perception is reality thing, right? If everybody perceives that something's bad happened and you're not to be trusted with their data, or that you're misspending government funds, then perhaps you need to really sit down and take a closer look at these risks. So step one in assessing them is, what questions do you ask? The next question is, whose job is it to ask those questions? Right? It's great to come up with a list of questions. You identify the risk, but who is it that's going to assess them? Well, again, that will vary from entity to entity. It could be your IT department. It could be your CISO, or Chief Information Security Officer. It could be your legal department. But even if you use other people in your agency or outside your agency, if you use their expertise, procurement should always, and I really can't stress that enough, you should always be kept in the loop, right? Even if the software or the solution that they're buying, the document that they're signing relates to a purchase that falls below your threshold. So in South Carolina, it's $10,000 for a small purchase. So really anybody within my entity could go and spend up to $10,000 without having to go through the competitive procurement process. If it's software and there are terms and conditions involved, I have to see it, because I need to track that. I need to make sure that that our entity is not being exposed unnecessarily to all those things that I talked about already, to damages and liability and bad reputation and all those things. And I need to see that and review those things before they are signed, before. I had a couple where they send me these signed documents after the fact, and then it's really just a question of how do we get out of them. And it's important, especially where you guys are, because from what I can tell in Washington State, it looks like there's the potential for you to be held personally liable for those things. So it's not just your city or county or whatever entity you work for is on the hook. It is, if I live there and work there, it would be me, Nathan Dawson, as an individual, whose pockets they might come for in order to make some of those reparations and damages. So as a procurement professional, it's your job to keep a track of what contracts your entity is party to. And it's up to you to make sure that you identify the risks, and then that you got the risks assessed, and that all of that was documented. The final bullet on that screen is just to remember to get that assessment in writing. And again, for your visual learners, I think that picture is the most safe for work way I can think of saying what it is that I'm really trying to say. Yes, cover your donkey. So, any questions on any of that so far? It's a quiet group. All right, so we've identified the risk, we've assessed it, and we've determined whether it really needs to be addressed or we can let it slide. Now what? Well, this is where, as a procurement person, your expert level of wordsmithing and negotiation skills really come to the fore. So here are some basic steps to help you. Unfortunately, really, in this area, the answer is the age-old answer to every single procurement question, and it depends. Like all the factors I just talked about, it depends on how critical it is, what you're buying, how much it costs, what alternatives you have if this one doesn't work, or you step away from the negotiating table. All of those things are going to impact what it is that you do and how you approach each situation. Again, the more you practice and the more you do, the better you get at them, if that helps. And obviously, if you're a bigger agency and you have a little bit more leverage in terms of buying power, that's going to help you potentially. But it really is just going to depend. And our assessment of the risk is going to inform how aggressively we try to change the language in a document, like I said, right? So my advice, though, is the first thing, bullet point number one, just ask for everything. Every time I send out a negotiations letter, strike paragraph 6, governing law, strike paragraph 7, limitation of liability, strike paragraph 8, terms and termination. You never know, right? You might get lucky and they might agree to everything, because they might, you don't know, it might be the end of the quarter and they're trying to make the sale to get that revenue guaranteed so they can report it and reflect it. So my advice is to shoot for the moon, as they say, get everything struck. Then when they come back, that's when you have to look at what are your deal breakers. If they won't budge, if limitation of liability is a deal breaker for you and they won't budge on it, then you need to know what's your backup plan. At what point do we walk away? And you need to do that before the process begins. And then you prioritize the risks that you have within a document. Then if you ask for everything to be struck and they say no, you know what the small things are that you're willing to agree to their terms on in order to get the big things to you that are really important, right? So if indemnification or data security is your bigger priority, you focus on those, and maybe you can live, you're in Washington, so maybe you can live with the governing law in Oregon. I don't know what the governing law in Oregon is like, but from where I sit, you're right next to each other, so it should be the same, right? Just like North Carolina is the same as South Carolina, same thing. So if you follow those steps, I think that will help. But like I said, it's really just a question of doing. And to that end, I now have some practical examples, which hopefully will apply those concepts that I've just discussed. So here's a common one. Like I said, term and termination. unless either A, modified by additional terms set out in the vendor's written price quotation or proposal to licensee, or B, terminated earlier in accordance with this agreement. The initial term of this agreement will commence on the effective date for a period of 3 years and will automatically renew for successive 12-month terms. Either party may terminate by providing the other party with written notice 60 days prior. Anyone want to shout out any problems they see with that one? Well, I'll go ahead.
I was going to say the auto renew for 12 months after having a
Mhm.
3-year period is really hard for agencies to track, and you'll miss that 60-day before the end a lot.
Yep.
Right.
Mhm. Yeah. And that's everything I put in there. I mean, you might have to, can you do 3 years up front? I can if I have justification for doing it here in South Carolina, but maybe this contravenes or contradicts what your solicitation said. You might have solicited for 1 year at a time, or 1 year and a max of 3 years. And maybe 60 days is not enough notice. It's probably enough notice for you to give them, but is 60 days enough time for the vendor to tell you to get out, for you to come up with an RFP or a backup, and to get the data transferred to the new person coming in? So those are the red flags on this one. Also, unless they modified it. So here, there's additional terms. Suddenly now I have to go and look at the vendor's written price or the proposal to see if anything has modified that, to make sure that that hasn't modified it even worse. So how do we solve it?
Hey,
I would ask. Yeah.
How do those automatic renewals impact those terms and conditions where they've put the hyperlinks in there?
Yeah, those hyperlinks they're live. That'll just stay. Once that hyperlink's in a document, it's in there, and that's partly why they do it, right? They only have to change the hyperlinked document once, and because the hyperlink is alive, it automatically refers to any agreement that they put out there that's linked it.
So
your automatic renewal, even if you sign it now in 2023 and you auto renew, and now we're in 2026, if they've changed it, you've agreed back in 2023 to the terms in 2026.
And they can change those hyperlinked terms and conditions 3 times a year without us knowing, right?
Right. Usually there's a clause in there that says this can be modified without your consent, but we'll let you know after we've done it. And so the next question is, how do you get around it? What I do is, before I make that award, I draft a record of negotiations, and I say that we have all of our documents. I change the order of precedence clause that we have that says the contract is made up of the following documents that will be looked at in this order. Solicitation is number 1, record of negotiations is number 1. Solicitation 2, amendments 3, proposal 4, all the way down to purchase order. And what I do is I print out those live documents, and I say this document is the one that is attached, and that's part of the contract. So if they want to change that later, we need to have a change order that does it. Does that make sense to everybody? Yeah. But that's a good question. That's exactly how it is. And the auto renewals are tough. There's a new, what's it called? Gatsby, the new federal accounting standard. I think it's 97 for lease documents. Is that right, Megan? Do you know what I'm talking about?
It's 87 for leases and 90 something or other for SaaS.
Right. So there's a new agreement now. Thank you, Krista. Gatsby 96. So what that says is, if you have to track them, right? As part of your audit and as part of your accounting now, you have to track your SaaS agreements. And if they auto renew, my understanding is that they count. If you do it for 12 months or less, or you give yourself a way out of that auto renew, it doesn't need to be tracked, is what I've been told by my director of finance. But that's something you need to look at. And like Maya said, once you've had it for 3 years, you might forget that there's an automatic 12-year renewal. Having said that, mine are usually year to year. with an auto renewal unless we try to get out, but we've set that and we put it on our calendars so we know to get out if we need to get out. So my advice to that one would be to strike it for me, because I've already included all of those terms and conditions in my solicitation. They don't have anything there that I haven't already put in the contract. So my argument is I've already addressed all of this. I want to take it out. Another super common one is governing law. Like I said, you're in Washington, but the vendor's in California, or British Columbia, or other places. So here it's from California. They want the state of California to govern, and they want the federal courts in the Central District and the state courts located in Santa Barbara County. Those are the highlighted portions, because those are the things that are problematic. Do you know the law in California? And if you're going to fight them in California, do you need to have a lawyer that you pay that's sat the California bar? Probably. Becomes even more problematic when you think about international vendors, right? Which are becoming more and more common in the IT space. So here's my advice. I would change it from the state of California to the state of Washington. And in this example, I am changing it from Santa Barbara to Klickitat County, which I've been led to believe is a real place. I always change it. I have never, probably shouldn't touch wood, I'm sure there's been an example, but usually that's the first one that they'll cede to. I think most vendors are realistic about it, and they're quite happy to get your business. And I think legally it makes sense that if your entity is located in Washington State and you're doing business in Washington State and using the product in Washington State law should apply, or Klickitat County law should apply. So I think governing law is pretty straightforward. All right. Thanks, Victor. Indemnification is another common one. As I said, this is compensation. So you will indemnify the contractor, its officers, its directors, its employees, and its agents from all liabilities, claims, expenses, and losses, including attorney's fees and expenses, arising from or related to any breach by you of these terms of service, including failure to obtain consent to provide personal data or otherwise private information. Indemnify all liabilities, claims, expenses, any breach. Those are very broad terms. We in South Carolina do not like it. We have passed legislation that says that state agencies cannot be held to indemnity clauses. It still makes me nervous though, because I don't want to have to go to court and try and argue that. So I always try and remove those languages. I always ask for them to be struck in their entirety. The fallback for me though is I always put to the maximum extent possible under the relevant laws. But that's because in my state, we have a law that says that we as a state agency cannot be made to indemnify a contractor. I don't know if Washington State has a similar situation. I don't know if anybody wants to share an experience on indemnification. It's one of the big ones that comes up, and it's one of the few that vendors tend to push back on.
This is Erin from Washington Health Benefit Exchange, and
Hey, Erin.
hi there. I can speak to this one. We run into this one often, and the wonderful thing that we did was early on when the exchange was established, because we aren't a state agency, we're kind of our own thing in the way that we're structured. So I reached out to the attorneys, AAG's office and DES, and asked their attorneys about indemnification, and actually have a nice written letter that says only a few organizations within Washington State that are named in legislation have the authority to indemnify vendors. And if you don't have that authority, you don't have, by law, you cannot indemnify a vendor. And we share that. We share that with our vendors whenever they push back on this. And that language they're sharing right now is very similar to what we use. And it's
okay.
Pretty
and does it work?
It does. It works.
Excellent. So if I understand you correctly, you're saying the default is nobody can indemnify unless they're specifically named that they can.
Yes, that was the gist of what we got.
Excellent. And yeah, that's, I mean, in case you can't read the chat, Maya has asked if you can share it, and Connie has asked, and I think everyone's going to ask you.
Go get your own. No. Of course, I'm happy to share. Maya, let's talk. Maybe there's a way I can post it publicly, or so people can.
Yeah, so we can post it in the Lunch and Learn documents on our website, and only members can get those. So if you're not a member, if you're not a Washington State member, and you probably don't want it because it only applies to Washington State. So anyways, it'll be uploaded onto the website. That makes sense.
Excellent. Thank you, Erin. That's a really good resource. And just to complete that, so when I go to pains to explain, and I've shared the law, and I've said, look, we can't indemnify you. It says that we're not allowed to, and I still get vendors that want to include that clause. They refuse to strike it. So I put that little underlined portion at the front. And to me, as far as I'm concerned, I put them on notice that we're not going to do it, and that clause is now modified. I'm okay with that, because like I said, I'm sure there have been cases where it's been tested in the court of law, but I just don't want to go through that hassle. So let's. And Megan says that the W2A adds the same language. Excellent. Okay, great. And that's important because, you know, that's a big, indemnifications are really common. These are all common ones, I feel like, but some of them are easier to get away with than others. And this one, they push back a little bit sometimes, but that's good to know. Thank you, Erin. The next big one is limitation of liability. So in no event will either party be liable under the agreement for any special, incidental, consequential, exemplary, or punitive damages of any kind arising out of or in any way connected with the use of the subscription service or anything provided in connection with the agreement, the delay or inability to use the subscription service, or anything otherwise arising from the agreement. And in no event will either party's maximum aggregate liability arising from or relating to the agreement, regardless of the cause of action, whether in contract, tort, breach of warranty, or otherwise, exceeds fees paid or payable by us to you in the 12-month period immediately preceding the event giving rise. That's one sentence for those of you counting periods at home. And this is a really common one. I'm sure you've all seen this. The problem here is the first half of it says that there's no way that anyone's going to be liable. And even if they are, you're only going to get back the 12 months worth of fees that you spent, right? So for software, you're always paying in advance. So you've spent that money. And if anything, what this is saying is no matter how much damages you suffer, you're only going to get back that 12 months worth of money that you spent. And they're not liable to start with. So that's the problem. And it's really broad. No damages of any kind that are in any way connected, in no event. So it's really broad terms that exclude pretty much everything. Anyone got any tips or tricks on this one? I mean, this is a big one, and this is one that I find that they push back on. So this is where your assessment, if you're only spending $5,000 on this software, and it's not a huge crucial part of what you do, and there's not hyper confidential information involved or data involved, maybe you're okay with it and you don't fight them too hard. What I tend to do is what I've done here. You can see that I've said I've doubled the amount of the fees, so I'm trying to get twice the money back. That's negotiable. You can ask for 3 times, or you can ask for it to be a certain dollar amount, or so much per student or client, whatever it is that you're dealing with. Because really, it's great to get your money back for the software that didn't work, but there's a lot of other problems involved now. Because at the very least, you're going to have to get another contractor to come in and fix that problem, or provide you those services that they were providing. Oh, well, that's not going to be done for free either. So maybe you say, we get our fees back and you have to pay us reasonable fees for us to provide the services required under this contract from another contractor. Or they pay the difference between what you would have paid and what you now have to pay.
Yeah, this is Jeff from Inner City. I've been getting this request quite a bit now to not exceed the amount of their fees. And I always like asking the question, I'm like, oh, so what risk am I missing here that would cause you to hedge your bets here or cause a problem? What am I not understanding with your product where you think that it could crash? And if your system crashes, that's fine. But if it takes down other systems within our system, then that's definitely going to cost more than just your amount. So you're saying that's a possibility? And then I get them backtracking, like, well, no, our system is, sound, safe. It will never do that. Then why do we have this clause in here? Yeah. And then they backpedal and they think about it, and then they determine they actually want to sell, and they kind of remove this stuff. But it does take quite a bit of back and forth for them to kind of understand that I'm not taking on the risk of you crashing our entire system and not getting compensation for it.
That's great. I like that strategy a lot. Megan says that she adds subject to agency's right to challenge enforceability. That's this clause, Megan, you're talking about?
Yes.
So subject to the agency's right. Okay. And how does that work for you? Do they push back on that? They're okay with it?
Generally, when I put that in, by the time I get to that point, we've argued back and forth for a little while. So we usually tell them, okay, well, it can stand, but we want to add, your gross negligence, blah, 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 and subject to our right to challenge the enforceability.
Okay, excellent. And I like that approach, and Jeff's as well. And then Erin has added, she basically says the cap doesn't apply to data breaches. So data liability due to data breaches, confidentiality breaches is not applicable either. So that's a great one. What I've done in that example on the screen is I've said the clause shall not apply to acts of gross negligence or intentional misconduct by the contractor's employees or agents. So the one I did this for was a very reputable, we dealt with them in the past, they're very good at what they do, and it wasn't crucial and it wasn't a big spend. So we just asked for double and to exclude those things, and they were okay with it. But those are all excellent strategies. I like all of them.
Looks like
and Jeff, I really like your approach, Jeff. Yeah,
Jason has a question too, it looks like.
Hi.
Okay.
Jason Nikonoski from the city of Spokane. So quick question using the data breach. A lot of times the data breach doesn't meet the criteria for gross negligence because it's just a misassignment of risk within their own organization, that they just didn't identify that as a risk. So it doesn't actually meet the criteria of gross negligence. So with that in mind, are we really mitigating the risk with this particular clause by putting in something else that's, for the most part, has a really high standard and high bar to ever actually prove out?
That's true, and I think you're right. And you're probably right. You probably need just to word it more strongly. I mean, if you want to include specific examples and say things like confidentiality breach, data breach, and define them, I think you're right, Jason. I think that's a much stronger approach. The only thing that makes me a bit nervous is as soon as you start to really provide a list of examples, they look at that list as being all inclusive. And if it didn't make the list, it doesn't count. So you just have to be careful with the wording. But you raise a really good point. What is gross negligence, and does it apply to the really important things that you're trying to protect? Same with intentional misconduct, right? Now you suddenly have to improve intent. So if this was a more important software that I was buying, those things would probably be spelled out a lot more clearly. And you've all raised the points for the last example I have is data security. I don't have an example of a clause because it's a real spectrum and gamut, right? And data is currency. Data is really important and crucial. We've all seen the increase in ransomware attacks and cybersecurity issues and phishing emails and texts and spam calls and all those sorts of things. So my advice to you as far as data security is look at your contractor security measures. What do they have in place? What protocols? what happens if there's a breach? Where are they storing their data, right? And is your entity fine with it being stored overseas, or does it have to be in the US? How is the data encrypted? Who is responsible for it in transit? And if you can classify your data using some sort of data classification tool, that's really going to help you determine how best to proceed. And so what I mean by that is you can group the data within your organization and say, this data is threat level midnight, red, high voltage, important data. We need high top level security on this. This data is medium, yellow, this is green, this is blue. So if you can classify your data and you're aware of which solutions touch which type of data, that's going to help you look at the data security in a much more meaningful way and not overpay for data security that you may not need, and then not have the level of coverage that you need for your hot data. So here's some examples for data security, security framework, data storage. These are all examples from contracts that I've done. What I like about these examples is that they refer to third-party. So for example, the NIST cybersecurity framework, SOC 1, SOC 2, and I'm running out of time to go into depth, but these are all independent bodies that have national standards, right? So when someone says they comply with the NIST cybersecurity framework, you know exactly what it is that they do and don't do. When you look at their NIST 800-53 or their SOC 2 report, you can see exactly, and you know exactly what it is that they're referring to. It's all encrypted in transit and at rest. It's all over HTTPS connections to and from the application. All passwords are salted and hashed. 2 business days. Is that enough time? Do you need it quicker than that? These are all the sorts of things that you need to look at. And then someone touched on this already, data backup strategy. Where is their fail-safe? Is there a backup? Is there a fail-safe? Is it located in the same building? Is it located on the same fault line? Is it somewhere else in the country, which is preferable, but then you're going to pay for that. So this one is a good example. They replicate it, and then the databases are replicated in near real time to a secondary geographic location. And you only lose a few seconds. So these are all the things, without going into a lot of depth. Data security is its whole other lunch and learn, which we can do next time or someone else can do for you, but those are the sorts of things. I'm happy to answer questions now. I'm happy for Megan or Maya or whoever to share that contact information if you need to reach out to me. That's my new email address. So feel free to share. Jason, you had a question?
Yeah, another question that's been a topic of discussion around here at the City of Spokane is treating software as a good versus software as a service. And what's your thoughts on pros and cons versus considering them in one category or another?
Oh.
Or is that a really long conversation?
No, so sorry. Say that again. They're referring to software as a
good versus as a service. So when you look at UCC, something that's transferable is a good. Many software licenses are transferable under a really broad definition. So part of the conversation is all software a good? Is all software a service? When does it become one or another? And is there a pro or a con for compartmentalizing them?
Yeah, I think the short answer to that is my understanding, and if anybody else wants to step up, feel free, but my understanding is the software as a service is when you're paying that other vendor to provide you everything that you need, right? They're giving you the software, they're giving you the patches, the upgrades, the maintenance, the support. You're really just entrusting them to do all of it. Whereas when you buy software as a good, as I understand it, it'd be like when you used to go to Best Buy and buy the floppy disk with all the software on it and install it on your PC at home. I've bought that software, I own it, and I have it stored on my own server. And then I'm responsible for its maintenance, its security, its upgrade, and all those sorts of things. So I think that could be the distinction.
Any particular risks you're familiar with treating it as a good, since it generally has
If
similar
you're buying it
regulations?
and you're hosting it, and that's a really good question. When people were really reluctant about going into the cloud several years back, that was their biggest concern, right? I've lost control. When I had it on my server in my basement, I knew who could access that room and that server, and I knew that the patches and upgrades would get pushed at a non-busy time, like at 3 o'clock in the morning on a Thursday. And now I'm at the behest of insert vendor name here, and they're responsible for the security, and can I trust them? And they're going to push patches at 10 o'clock in the morning on a Monday when all my clients are in the building. And I think those fears are less real now than they were, because I think those big vendors have taken those steps. But that's the real risk, Jason. If you're going to buy it as a good, does your entity have the knowledge and the wherewithal and the space to do everything that needs to be done if you own that software, as opposed to spend? Now, of course, if you go with the SaaS option, it's a lot more expensive in theory, right? Because someone's providing you all of it, but there's that trade-off. And Bobby Zengels shared a white paper on commercially available off-the-shelf software. So thank you for that, Bobby. And then you've got off-the-shelf versus customization. That's also true. If you own the software, Jason, and you know it's yours, you can upgrade it as you need, patch it as you need, and you're not sort of reliant. I mean, there are some softwares back in the day where you didn't want to ever push the patch because it always screwed something else up. So you would delay that patch as long as you could. But if you're buying software as a service, you don't get a say anymore. They're like, it's happening, bang.
Any other questions for Nathan while we've got 2 minutes left?
Quick thoughts on pushing back on warranty language. Yeah, warranty is tough. I think the idea is to try and get the warranty, delay the warranty start until you've completed all your testing and your acceptance and the thing is actually working, as opposed to when the thing starts, right? Because really they should be fixing things that don't work in the testing acceptance phase. And then you want the warranty to start once you're live and running with it, so that if anything breaks after that date, the warranty covers it. So you don't want to buy 12-month worth of warranty and then find out that you spent 8 months with the implementation phase and now you don't suddenly have but 4 months worth of your warranty left. That's really the only advice I can give. I hope it was enjoyable. I enjoyed being invited. Thank you. Maybe next time I come in person. I'll go back in time, because for me, it's 4 o'clock in the afternoon. I already have the winning lotto numbers and everything.
Yeah, we'd love to have you come in person. So thank you.
Yeah, I've gotten a couple comments just in the chat just to myself that, you know, really like the presentation and definitely love to have Nathan come out.
Thanks, Danny.
The Danny Drew ringer.
In the comments.
I actually got some people here to log in from different accounts and they're blowing it all up.
Got a good support team.
Yeah. Well, thank you. I did enjoy it. Thanks for having me. I hope it was useful. And like I said, if you have any questions, and you know, I'm more than happy to help if I can. And thank you, Erin, for uploading that document. That sounds really useful.
Yeah, for sure.